Hi everyone, I'm Chris Sweeney. I'm a staff attorney at Maryland Volunteer Lawyer Service. I'm going to talk a little bit about expungement today. I'm specifically going to talk about some unusual circumstances that arise when filing for expungement. The first thing I'm going to mention is an issue with identity theft or otherwise a client having a name on a criminal record that is either not their name or their name is on the record and it actually is someone else who was arrested in that case. These are sort of similar issues, even though they're sort of opposite in that way. We see a lot of clients who have a case on the record and then when we file for expungement, the police record turns up that in fact the person arrested was not the client. It was someone who used their name or something got mixed up along the way. And we also see clients who may have been using aliases at the time that they got arrested. So it was in fact them, but they're not the named defendant in the case. In both of these circumstances, you're probably going to get some type of objection from the court or the state's attorney, and you're going to have to sort that out in some way, either by having the client come to a hearing and testify, or in the case of a fingerprint mismatch in an identity theft, you're going to want to work with the state's attorney to come to some solution. It's unfortunately something that we haven't found a great solution to yet, but it's just an issue to be aware of in practicing expungement. Another issue that's been going on a lot is hearings getting called for petitions for expungement with marijuana conviction at issue. Marijuana possession conviction is eligible to be expunged after 4 years. Essentially, no questions asked. There's no subsequent conviction rule or any proof of amount required. We've been seeing an issue where certain courts are demanding proof of the amount of marijuana that was found on the defendant. So that's something to just be aware of when you're advising clients and filing that a hearing is possible in that circumstance. Of course, a hearing is also possible on more or less any case that you're filing for. We've actually been seeing cases with null pros, stats that are well beyond 3 years, and other types of seemingly eligible cases where a hearing does get set in without an objection from the state's attorney. So as a practice note, we used to tell volunteers and clients that hearings were more or less not an issue, that you weren't going to have to attend a hearing, but now we are having to advise both volunteers and our own clients that you could have to show up to a brief hearing on the expungement petition. Most of the time the expungement ends up getting granted anyway, but it's just something to be aware of. There's another issue going on with interpretation of the probation before judgment provision, which is that you're eligible to file 3 years after the date that the probation before judgment was handed over, or after the end of the probationary period, whichever of the two periods is longer. Now, in pretty much every circumstance, the probationary period itself is less than 3 years, so it's more or less a 3-year from the disposition date rule. Certain courts seem to be interpreting that provision incorrectly and counting down the 3 years from the date that the probation ended. So for example, a person had 1 year of probation and they're essentially claiming that the client has to wait 4 years from the date of disposition to file for expungement, which is not correct, but it's something to be aware of. You may actually even have a petition just completely rejected, so be prepared to advise a client on that possibility and to have to challenge that type of issue. One more thing I wanted to mention was just the possibility of encountering a case that has missing information on case search. We sometimes are working with a client and they might have a very old case where for whatever reason the information you need to determine eligibility for expungement is not on case search, or maybe the case itself is just not on case search at all, but the client believes there is an older case. In that circumstance, you would want to have your client get a fingerprint background check to try to find the case itself, and then you would go from there. And if there's missing information like a disposition or charge on case search is not there, you'll have to call the courthouse, see what you can find. You may actually have to go in person to the court and look at the file. If it's a very old file, you might actually have to end up going down to the Maryland State Archives and finding the necessary information. We do have some guides on our website about tracking down old cases and cases with missing information. So do check out mvlslaw.org for those practice guides and just information about applying for our services or becoming a volunteer. Thanks for watching.